Hello, hello, immigration fam. How is everyone doing? Good evening, everyone. Hello, hello, hello. Let me introduce myself for those who are just tuning in for the first time and for those who haven't seen me in a while. My name is Atty Odunlami. I'm an immigration attorney from the Odunlami Law Firm in New Jersey, and now we have an office in Houston. Hey, Houston people. All right, as you guys know, our mission and our vision is to help fellow immigrants get legal status, and no time is it as important as these times. This administration has made it really difficult to um, to get legal status. And so part of my job as an immigration attorney is to weed through what is true and what is not, because there's a lot of anxiety, there's a lot of information out there which does not necessarily pertain to people, but they think that it pertains to them. It makes them anxious to file their papers. It makes them anxious that their papers have not been received. So it's important for us to, as attorneys, to come on to tell you the truth as we see it in our practice. As I always say, knowledge is power. The more you know, the less people can take advantage of you. The more you know, the more you have peace of mind. And yes, these are very uncertain times, but guess what? Cases are still going through, cases are still being won. The federal courts were still appealing cases appealing laws that don't, that we feel are unconstitutional. And so your ability to get your green card has not changed. It's gotten a little more difficult, yeah, but you can still get your green card. So I want to talk about case types I'm seeing in my office, questions I'm seeing. Hopefully it will help somebody out there. So if you're just joining me, say hello. I always like to um, say hello to people. And then, of course, I'm going to, give what I have prepared, the conversation I want to have with you guys. And then I'll take some questions, okay? So, again, my law firm is the Odunlami Law Firm. Our mission and our passion is to help fellow immigrants gain legal status so that they can live here in the United States without fear of deportation, which is it's a real fear, or without fear of family separation, another real fear. So, hello, Sweet Tintin, good evening. And Johnson, good evening. So, the topic I have today, I decided to talk about this because I was getting a lot of consultations last week and this week with regards to permanent green cards. Apparently, there's a slew of people who have conditional green cards who apply for their permanent 10-year green cards and are being denied, right? So now the reason why it's so important for you to understand what you need to do is this. If your case is denied, you will be placed in removal proceedings. So I did a consultation last week. This woman had her I-751, and I'm going to go over what this is for those that do not know, had her I-751 denied, and 2 weeks later, she was placed in removal. This is what is being done now. I've never had anybody placed in removal or heard of someone being placed in removal within 2 weeks of a denial of their case. So when this woman came to my office, and she wanted to talk through what she could have done to avoid a denial, and I thought to myself, this is a good topic to talk about, right? And a lot of times, if your I-751 has been denied, don't fret. It's not the end of the world. It can still, you can still revive it. You can still reapply. You can do it and do it better. But remember, once you have an immigration history, which means you filed documentation in the past, know that all of that history is also a part of your current filing. So if there are discrepancies, those are the things that will sabotage your case. So let's talk about the I-751, what it is, and then we'll go to how you can apply, how you can file for it, and what the things, the top 5 reasons. I'll give you top 5 reasons that I've seen that are getting cases denied. So when you get married to a U.S. citizen, and you're, a green card holder, and the marriage is less than 2 years, you get a temporary green card. It's a 2-year green card. 90 days before that green card expires, you have to remove the conditions. Now, a mistake that people make, which gets their cases denied to, is that they file to renew the green card. You can't renew a conditional green card. You can only renew a permanent green card, a 10-year green card. So when you're married to a U.S. citizen green card holder and the marriage is less than 2 years when your green card is approved, you will get a 2-year green card. 90 days before that green card expires, you have to file to remove the conditions. Now, if you and your spouse are still together in marital harmony, in marital union, then you want to file jointly with your spouse. You want to make sure you're putting the right form, you want to make sure you're putting the right filing fee, and you want to make sure you're putting the right evidence that is required, and I'm going to come back to that. Now, if you're no longer with your spouse, there are 4 waivers. And waiver number 1 is a waiver of divorce. If you and your spouse are no longer together, you've gotten a divorce, you can file the I-751 on your own, because the waiver is waiving the requirement for a joint filing, right? You can file it on your own, showing that you now have a divorce decree, showing that the marriage was a bona fide marriage at the time you entered that marriage. And sometimes that is hard to show just because you may not have the evidence. And that's why it's important to gather all the evidence to show it's a bona fide marriage, right? Because when USCIS gave you that green card the first time, they want to see that more evidence of the fact that that marriage continued, or if it didn't continue at the time it ended, it was a bona fide marriage up until then. So if you listen to my live a week and a half ago, we talked about the evidence that you need to show to prove that you're in a bona fide marriage. We talked about that. Now, this is the second thing. The second waiver is a waiver of abuse. If you are in an abusive relationship, the government, the administration, does not want you to be in an abusive relationship because you want to get your green card. As long as your marriage was a bona fide marriage when you entered into it, which is on the date you got married, did you mean to live with this person, to be together for love, for companionship, and not only to get immigration benefits, okay? You have to show that, then you have to show the abuse. And like we've talked about before, abuse does not have to be only physical. Abuse can be emotional, it can be psychological, it can be financial, it can be sexual, it can be physical, of course, right? And talking about physical abuse, you don't need to have a police report. You don't need to have a hospital report. There are ways to show physical abuse. Maybe you have pictures of what was done to you. Maybe you have people that witnessed it and can write an affidavit, right? And sometimes a strongly worded declaration may be all you need, right? Now, let me tell you something. In this administration, they're really focusing on the need for evidence. So if you don't have enough evidence, or you feel you don't have enough evidence, it's important to talk to an attorney, because a lot of times you have more evidence than you think you have, right? Now, the third waiver is the waiver of death. If your spouse died in the interim, then of course you can get it waived because the person cannot jointly file with you. And then, but you also, in this waiver, have to show that it was a bona fide marriage. The fourth waiver is the waiver of a hardship. Now, this waiver doesn't necessarily require you to show a bona fide marriage, but it does require you to show that you're going to suffer extreme hardship, or that you suffered extreme hardship during that conditional period, right? Which requires you to be in the United States. Now, let me tell you the biggest mistake people make. They're in a bad marriage, it's not working out. Instead of going to file for a divorce so that they can give themselves the benefit of the divorce waiver, they don't. And then you get called for an interview and your spouse refuses to show up because you're not on good terms. And then you show up and you're like, well, he's not here. Your case is going to be denied because if it's a joint waiver, he has to be there or she has to be there. Now, if you had a divorce, you can stay and join the divorce waiver, and all you have to show is a bona fide marriage. Because if you're filing a joint petition, you not only have to show that you're still in marital union, you have to show that it's a bona fide marriage. And USCIS does not want all the old, information you gave to them before. It's okay to add it, but they want to see additional stuff. They want to see proof that when they gave you that green card the first time, that they made the right decision. And as for a lot of people that didn't get an interview with their first marriage when they got the conditional green card, trust, they're going to call you for an interview. And you better have good evidence for that. In the past administration, a lot of interviews were waived and where they basically made decisions on the papers. With this administration, they have said everybody's going to be interviewed. Even if you were interviewed before, you're going to be interviewed again. And if you were not interviewed before, you definitely will be interviewed again. Count on that. So having your evidence, proof that it's a bona fide marriage, is really important. If you're using the waiver of abuse, you're going to have to be able to tell your abuse story, what happened, how it happened, how it made you feel. I have, if you Google, I think I've written something about how to write a VAWA declaration, even though I-751 based on abuse is not technically VAWA, but it's along the same lines when you're writing a declaration. So check it out. It goes, it talks about how to write a declaration, okay? So the second waiver requires you to be able to prove there was abuse in the relationship. It requires you to prove that it was a bona fide marriage. The third waiver, which is a waiver of extreme hardship, maybe you're from a country where, terrible things are happened, you cannot return, or something really bad happened to you while you were here in the United States and you really can't return. That's the waiver of hardship. So there are all these 4 waivers that are available, but people still take the risk of going to the interview by themselves because their spouse is not showing up and thinking that it's going to make a difference. No, if you're not filing jointly, you need to have access to one of the waivers. And if your relationship is not working out well, and you want to get a divorce, you need to get it as soon as possible, because if you get called for an interview and you don't have a divorce waiver, a divorce certificate, you're not going to get that waiver. It's not, I filed a divorce and I'm waiting. You have to have a certificate of a judgment of divorce. So let us talk about the 5 reasons I have seen why cases get denied. Number 1 is if you were married before, say you were in another marriage, you got divorced, you married a US citizen or green card holder, you filed a petition, they gave you a conditional green card, and you think, well, everything is good. Guess what? USCIS has the right to review all the evidence you submitted before. So they may have accepted your divorce decree with the first filing, but there's nothing that compels them to accept it with the second filing. So I've had people come for consultations where USCIS accepted the first divorce decree and said it was fine, and then the second removal of conditions, they're saying, we did a research on this divorce decree and we don't believe it was properly done. We don't believe you're properly divorced. Therefore, we're not giving you a 10-year green card. And when they deny it, guess what? You're putting removal proceedings. So it's important that if you have any questions about your divorce decree, right? If you don't think it was properly done, you need to talk to an attorney so that you can determine how to. It might require you to divorce that person properly again. Typically, we recommend that you file the divorce here in the United States. That way, they're not questioning the divorce. It might require you to remarry your spouse and refile for another green card, because if you got a green card on a divorce that was not properly done, that green card was not properly obtained, and there are many things that you're going to need to do. Or maybe you qualify for another pathway. You might now have a T visa claim, a U visa claim, a child that can file for you. Who knows? But one thing you don't want to do is to think that because you submitted this document in the past and it was okay with USCIS at that time, that they're locked in. They're not. They're never locked in with any evidence you submit. They can always challenge it. And it's not an excuse that, oh, my ex-spouse used that divorce decree and was able to get their green card and is now a US citizen. That's them. Good luck. I mean, they scaled on that, but that doesn't mean that you are going to get off with that divorce decree. So that's something you need to know. Now, another reason that people's I-751, they get denied is they think it's going to be easy because they got their green card. They think because it was a bona fide marriage and, they don't have to show much and, that they can skate in free because, I got it the first time. It was really easy. I'm sure it's going to be just as easy. Let me tell you guys, I-751s are harder, in my experience, than getting your green card the first time. And the reason is because USCIS gets to review your case again to determine if they made a right decision the first time. And even when you're filing for your naturalization, I'm going to give you this free tip. USCIS can go again to review the basis in which you got your green card the first time. And if they don't think it stands, strong, they can deny your naturalization and they can take your green card away from you. All right? Now, another reason that people they get the I-751s denied is they're not filing with the right form. They're not sending it to the right place. They're not putting the right amount of money, right? The filing fee. You pretty much have to, there's no room for mistakes with this administration. There's no room for mistakes. So you want to make sure that whatever you've submitted is done properly. And another thing another tip I'm going to give you, whatever you submit to USCIS, make sure you have a copy of it. If you have an attorney that filed it for you, make sure you get a copy. If you have a notarial, which I don't know why you would want a notarial to file for you, but the people that do that, your cousin's brother, sister that helped you with your petition, make sure you get a copy. I cannot tell you how many people come to my office for consultations and they tell me, well, I'm not sure what was filed. I'm not sure what I signed. I don't have a copy. That's unacceptable in 2025, okay? You need to make sure that you have a copy of whatever you submitted or is submitted on your behalf. And then, what else? Another reason why your I-751 is denied, you committed a crime. You committed a crime and, that's going to get your green card yanked. It could be a crime which you are charged for. It could be a crime involving moral turpitude. Definitely, if it's an aggravated felony, that's a no-no. You're out of luck with that one. But for a lot of people, I'm going to tell you that most people are not getting their cases denied because they commit crimes. They're getting their cases denied because they don't know their burden of proof. They don't know what they're supposed to submit. They don't realize that the burden of proof is on you who is seeking to get your papers. USCIS doesn't have to give you a chance to get it right or to fix it. Come correct the first time, all right? And now the I-751 interview. That is a serious interview. Now, unlike VAWA, where the officers don't interview you and ask you questions about the abuse, with I-751 interviews, if you file based on abuse, they will ask you questions about the abuse. And guess what? That's really hard because a lot of people are still in the healing process, right? So it's important to be focused, to be calm, and to be able to answer questions, right? I-751s, when you file the I-751, of course, they give you a 4-year, the receipt notice, which extends your green card for another 4 years while they're making their decision. And during that time, they can do a fraud investigation. They can do all manners of investigation to figure out whether you got the conditional green card validly. So it's important that when you're filing for your conditional green card, that you don't assume that it's a walk in the park. It has never been, and it definitely will not be right now. So you want to do it right the first time. I-751s, especially ones based on abuse or based on divorce. We do a lot of that. If you need our assistance, we're here to assist you. You can give us a call at 973-993-1900. I don't have our Houston number, but if you call the 973 number, you will get to us, okay? So let me see if I can answer a few questions, and then we can go from there. So Johnson says, if you have a pending asylum case, do you have to pay the new filing fee? Yes, there's a new filing fee for pending cases, and you do have to pay that. Sweet Tintin, you're welcome. You're welcome. Just Jaguar, can you please give me an idea of the price range to process T visa? So Just Jaguar, it's hard to give you a price range when we don't know your case, right? And I'm going to tell you that, yes, how much a case costs is important, but what's most more important is making sure that you qualify for this pathway, because there's a lot of people that will charge you whatever and file a T visa case that is not properly done. So when you talk to an attorney, you want to make sure that you're comfortable with the level of knowledge. You want to be comfortable with the fact that you know that they understand what they're supposed to do, and that they're invested in doing your work properly and in the right manner, okay? So you can invest in your future by doing that consultation. And if you don't feel comfortable with that attorney, you should go to another attorney, because this process takes a long time. You don't want to be one of those that are, like the people that come to my office. I have never heard from my attorney. They don't call me. I don't know what's going on. You don't want to be one of those, okay? So Famara says, I did my green card interview and you're still waiting on your final decision almost 1 month now, but on the portal, it says your case is actively reviewing and nothing is outstanding at this time. Famara, that's not unusual. Sometimes USCIS will give you an answer right away. Sometimes they take their time. Sometimes they just want to review other documents. And so, and I can tell you that sometimes it even takes months, a year. So, if your interview went well, then just hang in there. 1 month is really not a long time to wait to get information on your case, okay? Then Political Pen Owner says, can you explain why USCIS will deny citizenship and take away a green card? Oh my goodness, Political Pen Owner, there are many reasons. The citizenship has requirements. First of all, the basis of your green card, if USCIS feels that you got your green card through misrepresentation or fraud, your green card, they will deny you your citizenship, and they can put you in removal proceedings to take your green card away. If USCIS thinks you didn't qualify for the green card in the first place, for instance, I think I had a case a while ago where my client came into the United States because her father filed for her as a single daughter, which is 21 and above. And she went through the interview in her country, the consular processing, got her green card, and then, got the green card approved and came to the United States under the F2B category, which means that she's a single child of, I think it was F1, single child of a US citizen, F1 category, right? And then she stays here 5 years, she qualifies to get her file for naturalization. And when she went for the naturalization, that is when she let USCIS know that, she had been married before she left her country. And that was in violation of the green card type that she got. Now, she didn't realize that she shouldn't have gotten married. But the thing is, if you're filing under this category, that's the category you need to come in with. So if she had come into the United States and gotten married, that would be fine. But you can't get married when somebody files a petition for you as a single person. And so when she went for her naturalization, they denied her the naturalization. And that was because of that. But luckily for her, right, because we're representing her, they didn't put her in removal proceedings, right? Now, there are ways for her to still get her citizenship, but it now becomes a little complicated, right? Now, you can also get your green card, your citizenship denied if you committed a crime or a crime involving moral turpitude or aggravated felony. They will deny your citizenship and they will take away your green card. When I say take away your green card, it typically doesn't happen right there. They put you in removal proceedings. So when you go before the judge, you have an opportunity to present your case and present why you should be allowed to keep your green card, okay? So there are many reasons why people get their citizenship denied and their green card taken away. And so when you're applying for citizenship, don't assume that it's going to be like, they're going to check all the boxes and you just walk out with that. They always go back to how you got your green card. They want to make sure that you're a person of good moral character. Another reason why you can get your citizenship denied is if you're not paying child support or you owe IRS money. Now, that may not lead to you getting your green card taken away, but it typically will lead to your citizenship being denied. And this administration is saying that if your case is denied, they're going to put you in removal. Whether they will do that in those instances where you just fail to do something which doesn't, I guess maybe may not be as that serious. We don't know because it just started, okay? So political pen owner, applying for naturalization, which is going to get harder come October 20th, right? If you haven't applied, put in your application now, okay? It's important to realize that USCIS is allowed to go back and they can review other people's filings. For instance, if you have an ex-wife that filed and there's some discrepancy in her application or your application, they can begin, anything can really be questioned, okay? So hope that helps, okay? So let me answer some questions from Instagram, and then I will answer a couple of questions from TikTok. Let's see, any questions on Instagram? All right. When I scroll so fast, it makes me dizzy. So I am, Abby said I had my biometrics. How long should I be expecting my interview and work authorization? It really depends on what kind of case you filed. I'm going to tell you things are moving pretty fast with interviewing in marriage-based cases and even work authorization. So, typically, definitely within less than a year, maybe even sooner. So, Buvana says, I am an OPT and I want to get an R1 visa. So, Buvana, to get an R1 visa, which is a religious visa, you have to have a religious organization which is willing to employ you in a religious capacity. And you have to be in legal status, which you are, OPT, which is good. And you must never have violated any status you had in the past, like your F1 or whatever. So if you have a religious organization which is properly designated as a non-for-profit, they're willing to file for you. Give us a call, 973-993-1900. Make sure that organization is the one that's calling us because they will be our clients because they're filing for you, okay? Now, a lot of people think that you can get an R1 just because you belong to a church. Well, you also have to belong to that church for at least 2 years. It's not automatic. That you have to have a job offer in a religious capacity. The religious organization needs to be willing to file for you, and they need to make sure they're compliant with all the rules, okay? And we've been able to do that really quickly for some of our clients. I know we got one last year, literally because we did the premium processing for them, and they literally were able to transfer from a B1, B2 to an R1, and literally within like three weeks, because like I said, we did the premium processing, and we actually did a couple of cases recently where the client had previously been denied when somebody had filed for them, but they came to us and were able to refile their R1, and it was approved. So that was great, and they were still in legal status. Remember, you must be in legal status, because I get a lot of calls. I've been here for 5 years. I want to get an R1. You have to be in legal status, okay? Any employment visa, any employment pathway, you need to be in legal status. All right? Okay. So Crown Baller says, after a T visa is approved, how long does a T visa recipient to be approved for a green card? Well, typically, when your T visa is approved, you can be in the T visa status for 3 years and then apply for your green card. And it really depends on when, because I can't tell you what they're going to be doing in 3 years. However, sometimes when your T visa is approved, we can accelerate the request to approve to file for a green card without having to wait to be in T visa for 3 years. But typically, I-485 adjustment of status, typically within a year, at least now. I can't tell you what's going to happen in the future, but that's what we've been seeing, okay? So I answered this question already, Bovania. And I think if you are out, the thing about R1s, one thing is you can file for an R1 if you're in the United States in legal status. You can file for R1 if you're outside the country and somebody's willing to file for you to come into the United States. That can be done as well. All right, let's see. So Mr. Slim says, what do you advise someone who's married to a U.S. citizen but yet to file? Is the submission after 2 years a good route? And what would one expect to use to prove before submission? So Mr. Slim, that's a loaded question. You wanted to wait 2 years before you file. What that means is when you get a green card, you'll be getting a 10-year green card. Now, as for what you need to show is a bona fide marriage. You need to show that your the person who's filing for you, your U.S. citizen spouse, is making, has income, or if it's not, if the person has no income, they have somebody who can file a joint affidavit of support. You want to make sure that the person who's filing for you has never been accused of any kind of sex crimes against a minor, because they are not allowed to file for people, subject to very limited exceptions. You want to make sure that you have no inadmissibilities yourself. You haven't committed any misrepresentation, any fraud, or any crimes that make you inadmissible. There's a whole laundry list which I can't in a Facebook Live, but if you wish for us to assist you, we're happy to do so. Please call us at 973-993-1900, okay? So Political Pen asks another question. Why are green card holders afraid to travel internationally? Well, I think it's because CBP is being very, very aggressive at the border, and some green card holders have some issues. Like if you have like a marijuana conviction from 20 years ago, which has never been a problem all these years, it's likely a problem now because this administration is very, I guess they're being very aggressive with people who have any kind of crimes in their past, or any kind of even misdemeanors. So when you're a green card holder, you will be allowed to come into the United States, right? However, if you are found to be inadmissible, you will be placed in removal proceedings. So that's why they're afraid, right? But if you travel and you commit, you're married to somebody, USCIS sees you traveling with somebody who's not your spouse, yeah, they can put you in removal proceedings. So the reason green card holders are afraid to file, some green card holders are afraid to file, is they're afraid that they may come before CBP and then they may find something that's a problem. So I think it's a fear that's valid because CBP has a lot of discretion, right? But there are a lot of people who are traveling outside and they're coming back without a problem. So I think, I think you need to check your history. And if you're really afraid, I even know US citizens who are afraid to travel. So I think it's really, people are just afraid because there's a lot of, we're seeing a lot on social media about people not being able to come back in. But a lot of this is really inflated. I'm going to tell you that. But it's not without cause. So if you have some concern, you might want to talk to a lawyer and discuss your immigration history, okay? All right, so let's go to, I'm going to go to TikTok and answer some questions. So TikTok says, how long does it take to get a green card from adjustment of status on B1, B2? to get a green card, marriage based from adjustment of status when you have a B1, B2. Typically, we're seeing this move fast. I'd say like if your case is approved and everything goes fine, definitely within a year, we're getting interviews within, I'd say like 6 to 8 months. And sometimes you get approved on the spot. Sometimes they take a little while. But like I always say, if you're going to file for this case types, you really want to talk to somebody who you trust. Okay. And so Aslock says, is it still safe to travel international with an advanced parole document, even if one doesn't have any past crime? It's a risk. And even before this administration, we have always told our clients, when you travel with advanced parole, there's no guarantees that you're going to come in. And we've always told our clients that. And some of them will still travel. And we've never had a client that traveled that didn't come back in. But just because you have an advanced parole document does not mean that CBP must let you in. Okay? So it's how much risk are you, it's a risk, especially now. I mean, you can tell from all those schools like Harvard and Yale and all that basically we're calling their students back in before Trump took office, like everybody come back in. So there's a concern that we're not quite sure, we don't have that confidence that the border, that CBP is making it easy for people. But on the other hand, like I said, there are a lot of people who are traveling, coming back with no issues. You have to determine whether it's a risk you want to take. So Michael says, my EAD based on a pending VAWA I-485 is 7 months now. Things are difficult for me. Michael, you can file a request for to get your work permit expedited. You can do that. You have to be able to explain what you're going through and why it needs, why you need that EAD as soon as possible. Sometimes you can request an expedited EAD and it's expedited and you get it. We've done that before for some of our clients, and it's worked. So Monal 68 says, can someone who's waiting for asylum hearing, which is scheduled for 2028, marry a U.S. citizen? Now, of course, you can always get married. Nobody stops you from getting married. Just make sure it's a bona fide marriage. That's it. The requirements of getting married is still the same. You can actually have your U.S. citizen spouse file for you under that pathway, because you can have multiple pathways. So guys, it's 5:30 Central Standard Time, 6:30 Eastern, and I'm gonna hop off now. I will be back next week. If you have any questions, feel free to reach out to us. You can ask questions right here on the comment section. We come back and we review it so that we can answer those questions when we do the next live. I hope this live was informative and helpful, and if it was, please feel free to share, because like I say, knowledge is power. We want our fellow immigrants to be able to live here in the United States without fear of being deported. We want to make sure things are done right for them, so that they can live the American dream, okay? So take care, everyone. See you next time. Bye-bye.